Now, we've put in a lot of groundwork to get to this point. We've looked at what law is, the legal system in Australia, how it developed, how we decide which government has which power. We looked at the three arms of government, and as a result of that, we started to see that our common law system is made primarily by two arms of that government, the legislature and the judges. But how does that affect business? Well, the way law mainly affects business these days is via Parliament making a law. So why do we do all that stuff about the judges? Well, now we're going to find out. Because part of the real problem is law written by Parliament isn't always clear. Take this example here. I've tried to get a little bit of a dad joke one for us and also a real world one so that you can see it applying. Let's hop in and have a look at this problem of statutory interpretation. So imagine you go to a bar Saturday night and there's this sign that says, by law, audience members are not allowed to bring glasses onto the dance floor. How will you be able to see your dance partner and judge whether they're a good dancer or not? Okay, I know, a bad dad joke. But what does glasses mean? Does it mean spectacles or does it mean a drinking container? The law here is unclear. Here's a real-world case, Carr's case. In this case, we've got a bank robber who's on trial. What happened was they were taken into the little room like you see on TV, and they were interviewed in this room, and then they were taken out to be booked and at the big desk, get their fingerprints taken, all that kind of thing. Now, when they're at the desk and as they're walking through the hallways, the criminal actually lets loose some information that they only could have known if they had committed the crime. What the criminal doesn't know is that at the time they're being recorded. But the police know that, and so they remain friendly and informal, swearing with them, joking, so that this criminal starts talking more and more about what they actually did. Now, why is this important? Because at the time, the Western Australian Criminal Code says evidence that police obtained by joking around with the accused person, that is not admissible unless the evidence is a videotape on which there is a recording of the admission. Okay, well, they've got a videotape of it from the hallway, so there's a little video camera up here, right? And they do have the videotape. But there was also a definition of videotape. The videotape was defined as any videotape on which is recorded an interview. Oh my goodness. So is this an interview? Is joking in the hallways on the way to the holding cells, etc., an interview? It's not clear, and the judges have to decide. And as you can see, the meaning of this word has a very big impact on this individual's life. By the way, I won't keep you in suspense. They actually said yes, it was an interview by a majority, split decision by the High Court. Legal writing can be super hard to understand. It can have double meanings. So the judges play this crucial role in interpreting what these words mean. And remember, according to the doctrine of precedent, once it's interpreted, that's the way that other judges lower in the hierarchy have to interpret the same words. Now, originally, judge-made law was the source of most of our law, so it wasn't a real problem. But as we've got the growth in statutes, this becomes more and more of an issue. And what we find is that judges can expand and contract the impact of law based on their interpretation of words within the statute. As a result of this, courts have developed a number of principles or rules. We're not going to go through all of them, but what I do want to do is go through some and show how that's developed over time into the approach that we currently have. I think that there's a nice quote here by Spiegelman showing us how some of the early rules that we touch on, which might not be as directly applied these days, actually inform how judges approach modern statutory interpretation. Let's hop into it. In this module, we're going to concentrate on a couple of the early rules, just a few of the early common law rules. Remember, these are rules that judges developed themselves. Then we're going to look at the purposive approach, which was Parliament's response to judges interpreting their work, to end up where we are now with the contextual approach, which is the predominant approach to statutory interpretation. So early on, the common law or judge-made law found courts developing their own rules to help judges facing ambiguity in statutes. There are a whole lot of them, but three that I think are most important to be familiar with are the literal rule. So the first rule was you should read a text literally and give words and phrases their ordinary and natural meaning. Parliament has written this down. If it's clear what it means, we should implement what Parliament says, the literal rule. However, sometimes that can lead to an absurd result. Think back through to that example of glasses on the dance floor. Some might say it's absurd that you couldn't wear your spectacles onto the dance floor. If so, the golden rule would say you modify the literal rule, that glasses might mean spectacles. You modify that to avoid the absurdity. So you say, well, clearly glasses mean containers, right? For drinks, not spectacles, because of the golden rule. So interpret things literally, avoid absurdities. And then we have this development of the mischief rule. So rather than just avoiding absurdity, the mischief rule develops to suggest that we should consider the problem or the mischief the legal text is intended to address. There is a possible argument that they don't want spectacles on the dance floor because, I don't know, maybe they could get knocked off, they could fall off if you dance vigorously and you could step on them and break them and then cause damage. So there is some argument that I'm sure a lawyer would make that it's not an absurdity not to wear spectacles. Well, if that were the case, the judge might turn to the mischief rule and say, what's the problem we're trying to avoid? And maybe the problem was, slips on spilt drinks. If that's the mischief we're trying to avoid, then we interpret the word to again mean a drinks container. So judges developed these principles about how to interpret words, but there was some freedom in how they did them. So to some degree, they could choose when or not they wanted to apply whatever rule, of course, within the boundaries of the doctrine of precedent. But it meant that there wasn't really clear the consistency of which rule they should apply over which. Normally, logically, you would go through the literal rule and there's no absurdity, so we go that way. But you can see how some judges might be able to interpret things according to what they wanted. As a result of this, parliaments came through, and I use the word parliaments because state and federal, parliaments came through and actually came up with an act or a statute or a law, an act that tells you how to interpret all the other acts. The Acts Interpretation Act. And so because of the way our system works, that legislation beats common law, if there's a conflict between what the Acts Interpretation Act says to do and what the common law principles are, the Acts Interpretation Act wins. It's called the purposive approach. Why? Let's have a look. The purposive approach is set out in the Acts Interpretation Act, either the Commonwealth, which became operational in the early 1900s, or the Queensland Acts Interpretation Act, which became operational some 50 years later. They have the same provision in them, which is important to statutory interpretation. This is this provision, which is taken from the Commonwealth Act, but it's the same in the Queensland Act. In interpreting a provision of an act, so when you're interpreting a piece of law, the interpretation that would best achieve the purpose or object of the act. Purpose. The purposive approach. So this legislated approach expands the mischief approach. You're not just looking at a problem they're trying to solve, you're looking at the purpose or the object of the act. And whenever you're reading a law, you should read it to best implement the purpose or object of the act you're interpreting. Now, as I've mentioned, since legislation trumps common law, it means courts have to interpret a statute or an act in a particular way. If you read the text and it literally doesn't reveal the unambiguous meaning of the text, then the reader or the judge needs to look at the purpose of the author. Sometimes the act or piece of legislation contains an object clause, which helps you work out what the object or purpose is. But really, really, really importantly, this approach allows courts to admit extrinsic materials in cases where there's ambiguity. So they can look at explanatory memorandum, what the minister says in Parliament. See what we said earlier around the speeches in Parliament. They can look to what the politicians say they were trying to do when they interpret it. And that's a very big change brought about. Under the common law approaches, you could only look at the text before you to work out this purpose. Now, the purposive approach allows you to look at other important materials that can help clarify that. Okay, well, that's starting to get all confusing. We're starting to have all these different approaches. Where are we? Well, one of the arguably best judges in Australia set it out this way. When you have a relevant law stated in legislation, then the starting point is the text or the literal rule. You've got to literally read it. What's it saying? Then you should look and try and identify the object and how you give effect to that purpose. Now, when you're giving effect, you don't just look at the text in isolation, but rather examine the sentence, the paragraph, and the context in which they're used. Thus, we can see the modern approach includes looking at things like the literal text, the purpose, and then analysing how they come together and the context that they're used in. But what does this contextual approach actually mean? Okay. An example might be helpful. Imagine you have this provision here: all building personnel shall not go within 5 metres of a crane without foreman. So do you have to worry about waterfowl? The birds, cranes. Well, look, you might think that that's stupid, but we need to think about the context that this provision is in. The immediate words around the uncertainty, there's foreman and building, so probably not a bird, more likely a crane that builds, given the words around it, if that makes sense, contextually. However, what act is it in? Is it in a Wildlife Protection Act, the object of which is stated to protect endangered species, especially birds? If it's in that act with the purpose, and they talk about cranes being chased by builders as part of the second speech, then the purposive approach says, no, this is about birds. So the context, the purpose, the context starts to change. Is the provision before it about builders not chasing possums, and the one after it, builders not chasing, water rats or something? You get the idea. In that context, this would mean birds. So you really need to look at it. To me, pretty obviously, it's going to be about cranes, the thing, not birds. But it's not necessarily so. The context really matters. So what have we got to do? We've got to look at the immediate words around it. We've got to look at the act as a whole. We've got to look at other legislation and other things that might have been said as part of the minister's speeches to identify the objects. We've got to look at prior law. We've got to look at the mischief they're trying to remedy, the problem. All of those things go into developing this contextual understanding of what the word crane means in this specific circumstance. So while it can seem complex, there's a little flow chart that can help you think through how most judges would approach an ambiguity in the language of a statute before them. It'd be something like this. The first question we'd ask is there a single clear meaning of the provision? So in our case of crane, we'd say no. There was no clear meaning. Crane could mean a bird, or it could mean a machine. Does the context offer a single clear meaning? Well, that depends what's around it. The context suggested building. So building, because it talked about foremen and builders, so it suggests a machine. So it'd say, well, it suggests that. Does the purpose of the act suggest a different meaning? Well, if this was the Building Machinery Act and the object was to make workers safe from machines, then no. So we would just simply use the contextual approach. However, imagine that the act was actually the Flora and Fauna Protection Act. Well, if it suggested that, we would have to look at the purpose, and we might say the purpose is to protect birds, so therefore it means bird. Again, it depends what's the acted in, right? Most times there's going to be a single clear provision where the context doesn't suggest a different meaning and the purpose doesn't suggest. So we would end up simply using the literal approach from our common law rules. So while it can sound a little complicated, hopefully you can understand how you can reason your way through what a word actually means to interpret a statute in the cases of ambiguity. Wherever possible, we should try and do it literally. However, we do have to look at the context of the ambiguous word and, really importantly, the purpose of the statutory provision that we're interpreting. Okay, so if I was you, I'd be going, Gavin, what the hell are you going on about this? I just want to do business. Well, in the real world, much of what you do relies on the interpretation of statutes. A very recent example, for instance, I just read is that there's a legal debate about whether Bitcoin is a currency or not under the ATO rulings, and a judge has come down and said it is, which is a big deal for tax purposes. Well, I'm not saying this is the legal case, right? I'm just saying there is ambiguity about how we tax something like Bitcoin based upon a legal interpretation, just as one example of problems that can arise and that affect business through statutory interpretation. And at the very least, you need to understand this is the reason why lawyers might not be able to give you specific advice. And they might say, well, on the one hand, right, you might not have to pay tax on Bitcoin, but I'd be a bit wary because if the other judges later overrule this when it's appealed, right, now you understand the kind of risk that you're taking if you to pay or not pay tax from a business perspective. And it doesn't matter what discipline you're in, you will face this problem. For instance, accounting constantly deal with acts and legislation. It's central to their role. Advertising and marketing, everything from misleading and deceptive conduct under consumer law to defamation, depending upon what you publish. Management, work health and safety, so many laws. Economics and finance, competition and consumer, like laws everywhere. Market structures, right? So many laws. And so what we're trying to do in this little video is not have you learn how to comprehensively read and interpret statutes. We're not trying to get that. That's what a lawyer does. But we want you to understand how lawyers approach the problem. One, so that you develop critical thinking skills. Two, so that you can make better judgments when you get advice from specialists. You know what's behind their thinking. And that's the key takeaway from this section on statutory interpretation. Okay, that's been a mammoth set of content. As I said before, it's very difficult when we have some people who know very little and some people who know a heck of a lot. I also understand that a lot of the approach in presenting this material has been stylized, truncated, etc. But we're really just trying to communicate the key principles of our legal system. Not so you can be a lawyer, but armed with this understanding, you can interpret the advice better when you're weighing business judgments. With that out of the way, we turn in the next module to look at one of the key rights and obligations in business, that of making and keeping deals, contracts.